2021, Monday. Is there to be retained? There is an IA.
IA is there, Your Lordship. It has been listed in the hearing, but it should have been listed in the orders, Your Lordship. As IA is yet to be disposed of.
Item number 51, list the matter on Friday in the orders or order column. Yes.
May I please, Lordship? Lordship, I beg to mention item number 31, my lord. Matter may adjourn, my lord. CD not.
We have not received the case date. Charge sheet submitted. Bhura,
My lord, I was an interim, my lord. Interim may absolute, my lord.
Can you come when the matter is called up?
My lord, Lordship. Obliged, my lord.
May it please your lordship. Lordship, I beg to mention listing of a bail application, your lordship.
Senior bench.
As I've checked, the cause list, court 8 is not sitting, your lordship.
Others are there.
Obliged.
Hey, please, Your Lordship. Lordship, I beg to mention item number 54, which may be taken along with item number 28 and 29, Lordship. They are similarly connected matter. 28 and 29, Lordship. Deeply okay.
Call up with 54.
Regarding, I don't know, 35, my lord, earlier CD was called and interim is there, my lord, against the petition number 2 and 3, my lord. But CD item 35.
we have received the case diary. Send back the case diary.
Up to date CD, call for up to date CD.
Yes.
Canon. Interim order passed earlier to continue.
Equality results from December 2nd. Good day.
Obliged.
For withdrawal, item 52.
Prayer of Mr. Sam Abdullah, learned counsel for the petitioner. Matter is dismissed as.
Oblige, Your Lordship.
Item 1, Mozambique.
May it please Your Lordship. Well, here, my lord, earlier it was rejected by Your Lordship, my lord. Your Lordship, earlier rejection order, my lord. Today I have come on the length of detention, basically, my lord, 78 days in custody. Earlier reject order is at page 18. 18 no. So, my lord, earlier reject order at page 21. And 78 days in custody.
No, 21 is allowed.
No, my lord.
One is allowed.
One is allowed,
Receiver
but
of the
petitioner
foreign
was
party
received.
and here's the second one is the Lordship.
Page 22, my lord.
His
How
prayer is rejected.
about the
Yes, paragraph
Paragraph.
5.
78 days, my lord, today. Other custody may not be required in also.
Yes, 50.
That's after appraisal of the case, they Lordship. After appraisal of the case, they Lordship rejected the prayer. Lordship.
No, he's only on length of detention now. Page 21, huh? Order. Will be only one petitioner. Who is the petitioner? No,
Tafazul, my lord.
number 2, petitioner number. There are 2. Earlier, the bail application being bail application number 347025 filed on behalf of the petitioner was rejected by order dated 7/11/25 by this court. After perusal of the CD, where it is noted in the said order that as per the CD, there is sufficient material against him. Where learned counsel for the petitioner submits that considering the length of detention of 78 days, further detention may not be necessary. Having regard to the aforesaid length of detention, therefore bail is allowed. 50,000, 2 sureties of like amount. One of the Elagam Estate. Para 7, okay, page 20.
Oblige your lordship.
My please, your lordship. Kindly, matter may be taken after some time, my lord. On behalf of ICB, he is on legs, my lord.
May I please, your lordship? Lordship, under section 310(4) of BNS, lordship. Lordship, FIR phase 8, lordship. Lordship, may be called for CD, lordship.
All right, CD.
8/12.
May please, lordship.
Your lordship, we have taken the instruction CDs remaining here, lordship, so charge sheet not submitted yet, lordship. So, yes,
My lord, today is 101 days. Page 18 is the forwarding, my lord. Arrested on 17/8/25, my lord. Page 18,
Rashid not filed.
not 5.
So default.
default bail, lordship. CD is in here, in our, this lot.
FIR is at page 10.
Hard learned counsel for the petitioner. Learned additional PP. The case against the petitioner is registered under find it page 18, okay, forwarding report, put the sections. It is submitted by learned PP that charge sheet has not yet been submitted. The petitioner has crossed the statutory period of detention behind bars since he was arrested. What is the date of arrest?
17/8/25, page 18, my lord. Page 18.
Petitioner is entitled to default bail. Accordingly, it is directed that the petitioner so and so shall be released on bail of rupees 50,000 with surety for like amount. Elagam Estate. Further provided that the petition cooperate with the investigation and try to imitate the witnesses. Petition stands disposed of.
Bless the Lord.
54, lordship, along with taken 28, 29, lordship, when the time will reach. Along with 28, 29 CDs, we have received the case there at time.
28, 29 is
Bail
bail
hearing.
hearing.
Yeah, bail here. Sir. In this.
Be taken up serially, lordship.
Item 4.
It please your lordship. Yeah, this matter is wrongly listed in motion column, lordship. The petitioner is already granted interim and case diary was called for, lordship.
Yes,
Take inspection whether CD is received or not. If CD is received, then they have fixed a date, lordship, will.
Lordship,
Even
I
in
fixed
time,
it
lordship.
on Monday.
the matter is wrongly listed in the motion column. As CD has already been called for, list the matter
Actually,
on Monday.
Monday.
Lordship.
Interim order passed earlier to continue.
Apply.
Next date.
May I please your lordship, with the instruction of my client, I may be allowed to withdraw this case.
You are Mr.
Yes, Das.
S. Das.
Yes, lordship.
On the prayer of Mr. S. Das, learned counsel for the petitioner, the case is dismissed as withdrawn.
Item 6. Please your lordship.
Here, the basic allegation against this petitioner was this, that he drafted one RTI application. His name was not figuring. So we could not file any FIR, lordship. The status report was called for from.
Yes,
Bangladesh
lordship.
PM, lordship.
We have received the status report. No cases been found pending against the person. Against the person, that's couple out.
It may be recorded, lordship.
Learned additional PP submits on instructions received that no case has been registered against the petitioner. At which PS?
Bangladesh PS, lordship.
The PS, hence the petition stands closed.
I'm deeply obliged, lordship.
Item 7.
May I please your lordship? Lordship, this is a case of a love angle going sour. Lordship, may I peruse page 20 for a moment first. Lordship has got.
Yes.
Yes, Lordship, may I read, Lordship? I, Navajyoti Lahon, permanent resident of Joysagar College, Sariali, presently residing in Bipul Enclave, flat number such and such, would like to lodge a formal complaint against Deepshika Gogoi, presently residing in Sujaya Enclave such and such. I met Deepshika Gogoi in November 24 and from January 25, we entered into a relationship. Since we had a good relation, we had planned to marry in future. Lordship may mark this, we had planned to marry in future. This is what I had said. But after some time, I learned about her past. She was divorcee who had taken alimony from her ex-husband, about which she kept me in dark. She had taken 3 lakh rupees from me and gold chain valued 3 lakh. Besides, I had to bear all monthly expenses, the screenshot of which is enclosed herewith. Recently, Ms. Deepshika Gogoi started blackmailing me by opening a fake account in my name and uploading personal videos in social media and pressurizing me to marry her and mentally harassing me on a continuous basis. Sometimes she goes to the extent of threatening to harm herself by taking a knife in one hand and taking video and blackmailing me to marry her. In addition to mental harassment, she had also physically harassed and assaulted me on certain occasions, causing both emotional and physical distress. I strongly believe that she intends to repeat with me the same pattern of financial extortion she carried out with her ex-husband, and she has friends who have been helping her to harass me. Her continuous stress, physical and mental harassment and blackmail have caused me severe mental stress and emotional disturbance. Therefore, I do not want to continue my relationship with Deepshika Gogoi and request you to kindly raise a case against Ms. Deepshika Gogoi and take immediate legal action to ensure my protection. I am ready to cooperate fully with the investigation. Lordship may observe on the top one, it's a GD entry. This was registered on 9/10/2015. The date may be observed. Now, after this GD entry was registered, then the police called her, and what she did is that, Lordship may come to page 16. This is the impugned FIR. May I read again, Lordship? As are regarding sexual intercourse under false promise of marriage. Lordship, in my FIR, I clearly said that I intended to marry her. With the due respect, I beg to state that I, Deepshika Gogoi, daughter of Binod Gogoi, permanent resident of such and such, the complaint for a kind consideration and necessary legal action. That I came in contact with Navajyoti Lahon through Instagram, son of Juga Lahon, such and such. that the accused developed a close relationship with me and promised to marry me. Believing his promise to be genuine, I entered a physical relationship with several times. That later I became pregnant as a result of this relationship. Upon informing the accused, he insisted that I undergo abortion, assuring again that he would marry me afterward. That under his pressure and false assurance, I underwent an abortion at Agile Hospital, Jayanagar, Beltola, and also accused entered a marriage agreement on such and such. As per marriage agreement, the marriage will be performed within 2 months from the concerned marriage officer from the date of execution of the marriage date. Now, thereafter, 17A, thereafter the accused started avoiding me and now refused to marry me and stating that he never intended to do so. The act of accused constituted a serious offense of cheating, rape under the false promise of marriage and causing marriage miscarriage. This is the sum and substance of it. Lordship, I submit it was registered under section 69 and 89 of the BNSS. 69 contemplates deceitful. Deceitful has to be from the very inception. Here in this case, what had happened is that she did not disclose about her being a divorcee. That went sour, and that's why this counter FI has been filed. Also, the CD may be called for and I may be protected in the interim.
Third learned counsel for the petitioner. This is an application on so and so. The allegations made in the FIR dated 5/11/2025. The entered into a close relationship with the tenant lady. And promise of marriage, she entered into a physical relationship with him. As a result of which she became pregnant. Subsequently, he underwent an abortion. For the petitioner as referred to the FIR lodged by the petitioner himself against the complainant much prior to present FIR, wherein certain allegations have been made against her. Further submitted that the present FIR is a counterblast to the FIR lodged by the petitioner. Call for the CD having regard to the event of his arrest. The petitioner is on interim pre-arrest bail of rupees 20,000 at one security of like amount. Satisfaction of the arresting authority in connection with the arrest. Further directed that the petitioner shall appear before the IO within a period of 7 days
1812.
and shall
Thank you,
cooperate with the investigation.
Item 2. I'm sorry, but I was in court number 24. Item 1 was there. My lord, I was behind the bar from 28 night. Today is 60 days, my lord, kindly. Earlier it was rejected by your lordship once, my lord. And other co-case has been granted bail, one by your lordship also, my lord. There was some orders and so.
What is the statutory period?
60 days, my lord, 406. 420. That was an. Yeah.
60 days. SPP,
As per my calculation, it is 28/9. 28/9 39 is 40. As to say, 8 days and 50. 9 days. 9 days. 50 days.
by the time CD is here, it will be over.
Earlier order of CD, the wife of the person CD, but without CD.
20.
He was produced on 30th of September, my lord. He was taken into custody on 28/9.
The data production is to be included.
Page 39. 39.
October, November,
59
What is
days,
today's-
59 days in that.
9 days. Page 38, my order date 25, para 1, 2. Earlier bail application. Bail application number P1/25 was on behalf of the present petitioner was rejected by order dated 14/11/25 upon of the case diary and finding sufficient material is the petitioner. Learned counsel. The petitioner submits that petitioner has completed 59 days in custody. Therefore is on the verge of completing the period and therefore his further detention may not be warranted. Above the prayer for 1,002 securities. Conditions, same conditions. Shall not correct negligence or intervention.
May I please, Your Lordship? Lordship, the allegation which has been made in the FIR is completely civil nature, but the informant given it criminal color just to harass the petitioners. Lordship, in FIR, kindly page number 18. May I read?
So CD may be qualified at this stage. Lordship. Agreement was made on 10/4/25. Lordship. Thereafter, and 10/11 have threatened up this.
Lordship, it is a common knowledge that while purchasing a property, a seller and buyer enter into an agreement for sale, not sale deed. In the instant case, an agreement for sale was entered into dated 10/4/2025 for total sale consideration of rupees 11 lakh. An advance amount was paid rupees 2 lakh to the petitioners number 1. It was agreed upon that after payment of further rupees 6 lakh, possession would
That
be
part is
handed over.
different, second part is different. Where allegedly was on
No, my lord.
10/11.
11/25. Lordship.
Fire was lodged on 11/11, so you can wait for some time.
So
CD.
interim may be given, at least. CD may be called for interim maybe.
So 11/12. Lordship.
Only CD.
Highly okay.
Please, Your Lordship. Well, the FIR is page 9. Here, my lord, 5 persons name mentioned in the FIR. The present petitioner number 1 is, my lord, the only first name is the similar. But he is saying that I am not that person. And present petition number 2 before your lordship is not named in the FIR. FIR is that, my lord, on 14/9/2025, my lord, at about 3 p.m. The FIR name accused persons, my lord, took the Aadhaar card of some person and find out the SIM card. And using the same Aadhaar card, my lord, more than one SIM card was my lord, find out and delivered only one to the original Aadhaar
We'll
card.
need the CD.
And he was a college student, my lord, maybe covered the interim order, my lord.
We know what kind of a student you are.
11, 12.
May please, your lordship. Lordship, pre-arrest bail application, lordship. Offense, lordship, 331/64 of the BNS, lordship. Lordship may kindly see the FIR page number 14. Vernacular version, lordship. May I read the FIR, lordship?
Yes.
The Azhar that complainant name is there, lordship, and the accused petitioner is the lordship, present petitioner, lordship, Abdul Razak. Pinto নিবেদন এই যে অপরপক্ষজন মোৰ বৰ্জনা হয়, he is the brother-in-law, lordship. আজি ইংৰাজী 2/10/25 তাৰিখে দিনৰ প্ৰায় 11 মান বজাত মই দাদীক চাব বাবে বৰ্জনা ঘৰলৈ গৈছিলো। পাছত মই ঘৰলৈ ঘূৰি অহাৰ সময়ত অপৰপক্ষজনে আমাৰ ঘৰত গৰুৰ কাৰণে ঘাঁহ চাবলৈ বুলি মই অহাৰ লগতে আহি আমাৰ ঘৰ পাইহি। তাৰ পাছত বাৰীত ঘাঁহ চাই প্ৰায় 12:30 মান বজাত গৰম উঠিছে বুলি মোৰ ঘৰৰ দৰ্জা খুলি ফেন চলাই দিবলৈ কয়। তেতিয়া মই সন্মুখৰ কোঠালীত দৰ্জাখন খুলি ফেন চলাই দিওঁ। অলপ পাছত অপৰপক্ষজনে তেওঁৰ গা বেয়া লাগিছে বুলি বিচনাত শুই থাকে আৰু মোৰ ওচৰলৈ মাতি কি হৈছে বুলি সোধাত অপৰপক্ষজনে মোক তোমাৰ স্বামী নাই, বৰ্তমান বেলেগ ল'ৰা চাইছা নেকি বুলি কয় আৰু লগে
Please, your lordship. Petitioner is ex-serviceman lordship. White order dated 10/30/10/2025 lordship. Additional session judge number 3 Kamrup convicted the person, upheld the judgment of conviction passed by CJM Kasar, wherein he was convicted for 6 months under NI 138 lordship. Beyond judgment is lordship, page 62. Lordship, the allegation is lordship, one check has been issued by the petitioner lordship to the accused, respondent number 2, amounting to rupees 6,50,000 lordship. And after going through the evidence on affidavit, the learned trial court lordship convicted the person for 6 months and compensation amount is 7 lakhs has been awarded. Lordship, no, the cross-examination and other evidences were not taken into consideration, lordship, at the time of passing of the judgment, lordship. That's why he is before this honorable court. At this stage, lordship, a notice may be issued and the judgment passed on 30/10 that may be stayed, lordship. Complaint petition is page 16, lordship.
Where is the appellate judgment?
Appellant judgment is page 62. This judgment, lordship, just upheld the judgment of the trial court, considering the facts as rightfully taken into, but lordship, after perusal of the evidence, lordship, kindly peruse page 21, lordship, page 21. This is the evidence on affidavit filed by the complainant, lordship. Page 21, Lordship, point number 2, he stated that he and the accused are known to each other since long time. Now, Lordship, in his cross-examination, page 33, kindly peruse. Page 33 is his cross-examination. He stated, I do not have any personal relation with the accused. And in the judgment, Lordship, page 51 of the trial court judgment, the learned trial court came into consideration that PW1 has categorically testified that he is a businessman by profession and he and accused are known to each other for a long time. This is on the basis of only on the evidence on affidavit. Learned trial court has considered only the evidence on affidavit, not the cross-examination. So, Lordship, there are other irregularities, Lordship. They have considered one hand note, which is a Xerox copy. That is not exhibited document. So on that basis, Lordship, conviction has been awarded conviction against the
Counsel for
appellant, Lordship.
petitioner. Learned additional PP. This is an application under (442) of the ENSS against the judgment and order of conviction. Section 130 of NI Act. Page 2, cause title. Taken, we didn't read it. Again, after 4 weeks. Yeah. Till the next date, the execution of the date. Till the next date of listing. Okay.
Highly obliged, Lordship.
Item 12.
There are two items, my lord, 12 and 13, my lord. Same person, my lordship, I will take up item number 13 first. my lord. The same petitioner, my lord. It's a quashing, my lord. Lordship, may have a look at page 19, the FIR, my lord.
Nineteen.
19, my lord. May I read, my lord? So that on some day in the first week of June 23, the below named accused had come to my house and told me that he has about 100 numbers of rooftop solar and per solar cost rupees 70,000 and he wanted rupees 5,000 per solar from me. Accordingly, on 23rd June 24, the accused fraudulently had taken 1,61,000 from me with a promise to give 32 numbers of solar within 1 week. I paid the aforesaid money in presence of the witnesses so and so. But till to date, the accused neither give the solar nor pay back my aforesaid money. In this way, the accused cheated an amount of rupees 1,61,000 from me. If I want back my said money, then he used slang language and also threatened to kill me. Hence this FIR, due to have a hope to get back my money lost on of FIR got delayed. In view of above, it is therefore prayed that your good self would be pleased enough to kindly investigate into the matter and do the needful action against the accused by registering a case under the proper section of law for the ends of justice. Now, Lordship will see, my lord, that on some day in the first week of June 23, my lord, and now this FIR has been lodged, my lord, on 21/06/25, my lord, after 2 years. The main intention of filing this FIR, the Lordship have a kindly look at page 36, my lord. 36, your lordship will see, my lord. This is an election result, my lord, panchayat election, my lord. My son, my lord, at serial number 2, my lord, Mamun Shah, my lord, he got, my lord, 4,149 votes. And the, my lord, the informant, his name appears at 4, my lord, Sofikul Islam. My lord, he lost this election, my lord. So therefore, he has filed this FIR, my lord. And the police, my lord, after investigating the case, my lord, filed the charge sheet, my lord, that your lordship will kindly have a look, my lord, at page 25, my lord. 26, my lord, I'm sorry, my. Page 26. The lordship will see, my lord, the charge sheet has been laid, my lord, under section, my lord, 61(2), 3184 and 3162, my lord. So far, my lord, 61(2) is concerned, my lord, it's a criminal conspiracy, my lord, where 2 or more persons should be involved, my lord. Now, 3162, my lord, the criminal breach of trust, my lord. Neither these sections are attracted, my lord, in the instant case, my lord.
318.
318. 318 is cheating, my lord. Cheating, my lord, in the instant case, my lord. In the FIR, my lord, when the transaction was done, my lord, nothing is there, my lord. And after 2 years, my lord, exactly after the declaration of the result, my lord, this FIR was lost, my lord. So far, my lord, 61(2) criminal conspiracy, my lord, it is not attracted, and 3162, my lord, the criminal breach of trust will also not attract, my lord, in the instant case, my lord.
Same.
এটু কি হবে, এটু কি?
Same date of the FIR.
And the next item, my lord, the earlier item, my lord, 12, my lord, same 2 affairs, my lord, on the same day, my lord.
Same complainant.
Here, my lord, in the item number 12, his manager, my lord. That's fine. Same language, same thing, my lord. After 2 years, my lord. The main intention of filing this FIR, my lord, is because he lost the election, my lord.
Yes, PP.
Subsequently, only submitted a record may be called for. Records may be called for at this stage, lordship. Along with the case diary, lordship.
All-
After the lordship will consider after page of the case.
I have an interim prayer, my lord.
You are on bail anyway.
My lord. But so far, my lord, item number 12 is concerned, my lord, the next date is fixed on, my lord, 27, my lord, 27/11, my lord.
That is for what?
For, my lord, appearance, my lord.
The difficulty in appearing.
I have not done anything wrong, my lord. Why should I
Let him
have?
also come. Hard learned, Mr. Angel. Additional PP. An application under so first title. To the rest. Two. Steps within 3 days by registered post ID. Call for the PCR. Code below. In on. Even that 4 weeks.
Can the further proceeding be stayed, my lord?
Just 4 weeks. What will happen in 4 weeks?
Because in other case, my lord, it is fixed on 16/1.
Yes, it is. Absolutely. Then what is the necessity of passing interim order? Interim order in-
My lord, I have observed.
Item 14.
The petitioners approach this honorable court for quashing of the FIR and the consequential proceeding, if any, which has been pending against both the petitioner, those are father and son. What happened in this case, my lord? Lordship may kindly turn to page 18 of the FIR, which is translated copy. The second paragraph, your lordship will find. May I read out? Today on 23rd of July 25, inside the chamber of Sri Anupam Boro, SCS Magistrate Rangia Sadar, Mohammad Saidur Rahman, son of so-and-so, and Mohammad Mustaq Ali, who is the petitioner number 2 herein, son of so-and-so. Both are residents of so-and-so. Are the land grabbers. Both of them attacked me physically and hit on my head. They attacked me in front of the magistrate, Sri Anupam Boro. Prior to that, on 10/6/25, they occupied my land by breaking the fencing of the land forcefully. Furthermore, on 25/6/25, they have stolen the construction materials and pakka post. On being confronted with police, they escaped from there by taking advantage of darkness. Police recovered the stolen articles and vehicle to the police station. The aforesaid 2 persons threatened to finish my family and to evict me by demolishing my house from the said locality. Apparently, they attacked me in front of the honorable magistrate and inside the chamber. And in view of the above, it is prayed for proper treatment and to arrest the both the petitioners. An appropriate punishment may be kindly be given to them and to secure my treatment, retirement, life and property. In
Yes,
this
so
regard,
why should we interfere in this?
Madam, Lordship may
All the
kindly turn-
allegations are there.
No, Lordship may kindly turn to Annexure 2, page 23. The cause of action accrued from firing on the date where it is recorded. Lordship may kindly record the proceeding of 23 July 25. Both parties present and filed hajira. Heard both the parties, it appears that both the parties are trying to occupy the same piece of disputed land, and there is a possibility of public breach of peace over the possession of the shoot land. Therefore, I am satisfied to draw a proceeding under section 164 of BNSS. Further, it is observed that due to the aggressiveness of the opposite party while opening the door, first party got injured. First party is the informant herein. In the forehead, if first party insists, he may file an FIR. Fix so and so next date for filing WS of the opposite party. Those are the petitioner hearing. So entire cause of action accrued from the incident while opening the door of the chamber of the London magistrate hearing was going on. So the act which was caused in this case was not intentional, and there is no major injury. So, my lord,
We are not going into all that.
so far as only due to this occurrence, this FIR has been registered, which was marked as GD&T first. Thereafter, it was converted into FIR, and the
We
sections.
cannot determine that.
And the sections those are invoked by IO in this case. My lord, those are no affected. Neither there is a, it is a case of grievous hurt, neither it is a case of any mischief, so and so. So, my lord, in view of the above, petition approached this honorable court for to quash because.
It is to be said at the stage of charge hearing,
My lord,
what sections are attracted, what are not attracted. The FIR clearly discloses offences. Why should we interfere here?
where is my disclosing offences, my lord? If someone unintentionally any injured caused by on the part of the petitioner while opening the door, who
We
is
don't
the,
know that.
who is the
That is not
backside-
what is said in the FIR.
Yes,
We don't even trust what the magistrate has said. Something may have happened.
my lord.
That occurrence may have taken place in his presence, but
is-
to hide that also he
but-
can say that.
But is it an offense, my lord? Yeah,
Yes, in my dictionary, hitting somebody on the head is an offense. It may not be in yours.
So, my lord, if your lordship will kindly follow the guidelines of the Honorable Supreme Court in the past in the case of Bhajan Lal, my
Yes.
lord, there are
FIR does
allegation-
not disclose an offense.
Yes.
In my view, it discloses an offense.
If the allegations made in the FIR, even taken at their face value and accepted in its entirety, do not prima facie constitute any offense or make out a case against the accused petitioners. So, my lord, so far as my understanding, my lord, there was no offense on the part of the present petitioners. More particularly, the accused number 2, petitioner number 2 was not present thereof. And the petitioner number 2, one is a 72-year-old person.
What is
And-
your name?
And the land dispute is going on between the parties. since-
Soedur Rahman.
Yes. He
Yes,
is a
mention.
retired teacher, and they were no involved with any kind of offense as alleged by them by executing clever drafting in the FIR. So that is to be looked into by this honorable court, because honorable Supreme Court in B. Jose, it is held that it is one thing to say that a case has been made out for trial, and as such criminal proceeding should not be quashed. But it is another thing to say that a person should undergo criminal trial despite the fact that no case has been made out at all. Therefore, considering upon the materials placed on record, it would meet the answer. Justice, this honorable court be pleased to quash the impugned FIR of the Rongia PS case number so and so, registered under section so and so. So far as the sections, those are nowhere attracted, and it may be a case of section 115.
We are not here to determine which section will be attracted. As long as a penal section is attracted,
So
it is
that's
for
why-
the Learned Trial Court to decide.
Trial court, the charge sheet has not been filed in this case.
It's in an investigation stage, so that
Yeah.
will, sort of in the investigation stage, it cannot be for the state,
Sure.
cannot be granted.
Third learned counsel for the petitioner, learned additional PP. This petition has been seeking quashment of a referred under section 528 of BNSS seeking quashment of Rangya PS case number 160/2025 registered under sections 117 in bracket 2. See from the cost title, okay, second. As per the FIR. Complainant stated that the petitioner Rahman Mustaq Ali, son of Sayyidur Rahman, prisoners number 1 and 2, attacked him physically and hit him on his head in front of the magistrate Anupam Boro, ACS. Rangya Sodor. It is further alleged that they have forcefully occupied the petitioners have forcefully occupied his land, and 25/6/25 they have stolen the construction materials and Pakka post. It is the further allegation that the aforesaid 2 persons, that is the petitioners, threatened to finish his family and to evict him by demolishing his house from the locality. There are Learned counsel for the petitioner submitted that case has been out on the from the offense of the FIR against the petitioners, that the provisions of law, that is sections, so is the FIR has been registered, not attracted in the present case. Learned additional PP submits that the case is at the stage of investigation. would be highly premature to interfere at this stage. For a petition. LPC and DNSS. It is, of course, the settled law that where no case has been made out on the contents of the FIR. Normally, call for interference in exercise of powers under Section 82 RPC stroke 528 BNSS. But in the instant case, I am of the considered opinion case has been made out against the present petitioners. They are taken at their face value. Regard to the also the fact that the investigation of the case is underway. Court declines to interfere. The petition stands dismissed.
My lord, one thing I'd like to point out, in this FIR which your lordship failed to consider. In the order sheet of Annexure 2, my lord,
Pointing out is over. Yes.
Your report was being called for, whether any case has been registered against the petition.
From here, no?
From
Because sometime, Lordship, we have not received any instruction. I have a.
May I please, your lordship? Well, this is a quashing application of FIR and consequential charge sheet, my lord. The FIR, lordship will find at page 28, it's just an omnibus FIR. The general statement, not against anybody, it's regarding the irregularities in the plan record office, my lord. Page 28, my lord. The revenue circle, the general FIR, my lord.
Who are you?
I'm just one of the person, my lord, who has been charge sheeted. Riju Ahmed, alias Raju Ahmed. I'm a local businessman.
You are alleged to be a middleman.
They have alleged that the basically allegation is the middleman. But the now lordship will kindly see, I was also arrested in this connection and I applied for the bail, page 32, bail order. Thirty-three, my lord. Relevant portion, my lord, second paragraph, page 33. Upon consideration, my lord. On available materials on record as discussed above, and after hearing the both sides, I am of the opinion that the accused person is not named in the FIR and there is no specific allegation in respect of the alleged offense against the accused person, either in the FIR or in the forwarding report, or there is no any other materials available with the North Guwahati case number so and so against the accused person. Record further reveals that from the FIR forwarding report and also from the available materials are not shown so. This not mentioned that the whom the accused cheated, where and how the accused has committed breach of trust in respect of the document, and the accused has committed forgery and the valid document had been used by the accused as genuine. That was the observation after perusing the case diary. Thereafter, my lord, charge sheet has been filed. In the charge sheet, 55 persons has been named, including me. That's in also just an omnibus one-line statement in page 81, my lord, implicating all the accused person. There's a prima facie case in 120B, 420, 409, 467, 468, and 471, including me. My lord, my contention is that, my lord, where is the question of 420? Because there has to be initial deception for the 420. 468, there has to be a forgery by me, or there has to be a criminal breach of trust as an agent, as a 409 has been alleged. 471, I must use or somebody must use a forged document as genuine. That material has to be there in the material. My learned friend will definitely will place the material if there is anything against me. Our contention is that all the statement recorded under 161, that's all the witnesses just implicated that we have heard from somebody else that this person may be involved in these kind of offenses, may be involved. That's a hearsay, and they are not also sure about it. And that does not create any prima facie material. For the accused to face the trial, madam. That is our contention, madam. Not a single witness has implicated us. 3 witnesses, they said, my lord, that they may be involved, and we have heard it. Definitely, lordship, my lord.
Yes, PP.
TCR received, lordship, we have not gone to the TCR, so let me go to the TCR, lordship, where in the case diary, lordship, anything, they are not already charge sheet submitted in this case, lordship. And it is just an opinion of an IO, my lord, it has to be corroborated with the material collected during the office investigation, my lord. Probably charge is not framed.
Today it is fixed for what?
Admission, my lord. Admission. Let him go through, my lord, in the next date, my lord, lordship. Fix it up, let him go through the charge. Precedent case there. Is there. Absolutely.
Heard Mr. Borderland, it's senior counsel for the petitioner. Petitioner PP pays for some time to go through the PCR, as this is a charge sheeted case. Hence, list the matter again on second week of.
Interim may be continued, my lord.
Interim order passed through.
Deeply of it.
Jail appeal.
Admission. Jail appeal.
No name is shown. So we have to appoint amicus. Oh. Hold it, just a moment. This is a jail appeal. Referred against judgment of conviction dated 06/05/24 passed by the additional session Judge Shiv Sagar, convicting the appellant under section 376 IPC. Para. Mrinmoy Dutta is appointed as prosecutor to read the registry to intimate accordingly. Is the matter again on 4 weeks? 2 weeks.
Yeah, Mr. Lord.
Right, his name,
My lord, by way of
the
this
name of
revision
Mr.
petition,
Dr.
I
is
have-
shown in the cause list. And column, in the appellant column. Yes,
by way of this revision petition, I have challenged the impugned order dated 14/3/2024. Page 37. And my lord, judgment for granting maintenance to the respondent number 2. But before entering the facts of the case, I would like to place that Rajneesh versus Neha is not followed while deciding that case.
This versus Neha is of which date?
It is 4/11/2020. This complaint is filed on 22/2/2022. Cited on 14/3/2024.
You are the second party.
I am the petitioner. The petition, husband, my lord,
His husband, you are the second party there.
second party, at the my lord maintenance case.
So you failed to submit.
My lord,
You failed to submit the statement.
my lord, specifically, my lord, that was not followed, in fact, my lord. Nobody submitted, my lord. Nobody submitted.
The Lordship has rightly pointed out that he failed to submit because Rajneesh versus Neha says at the time of filing WS, he has to submit it.
Yes.
That paragraph 72 is there, Lordship, clearly says. Lordship.
My lord, both parties should submit, my lord.
Yes, it is his duty, Lordship. That-
PCR is here.
Yes, and we have already submitted assets and liability, but he has not submitted, Lordship.
Then
Nothing, nobody has submitted anything.
what do you think? We don't want to know what you think. Give us the facts. Was the TCR is received?
Here received, Lordship. Only 3,000 maintenance is there. So here, 2 points are there. The first, Lordship, he filed this application under section, Lordship, 442. That probably is not the section for filing application, Lordship. He has to file application under section, Lordship, 438. That is earlier 397. And he has filed this application under section 401. 401 attracts only during proceeding of a case.
not for filing an application, Lordship. That in the 442 itself, it is mentioned, Lordship, that in the case of any proceeding, the record of which has been called. So if any proceeding is pending, then High Court can exercise power under section 442. And second thing is that, Lordship, here, as per Neha's resignation, Neha, Lordship, paragraph 72.3, it is the respondent who has to file assets and liabilities disclosure affidavit along with the WS. He filed the WS, but he did not file the assets and liability. So burden is on him. He failed to follow the resignation procedure. And by saying coming to the High Court, Lordship, he cannot say that court has not followed, Lordship.
My lord.
And only 3,000 was directed to be paid, and at present, Lordship, about 1 lakh is pending, Lordship.
Both parties is to submit, my lord.
And
I am the
I
second
already
party.
filed my assets and liability, that is already reflected in the order dated 4/11/22 trial court record.
Lord, page 13, annexure 1. My lord, is a contract of sale and purchase of a vehicle, my lord, from Fortic Rajbongshi with this present petitioner, my lord. And this sale letter, my lord, had been executed for purchasing of a my lord, ultra vehicle basing on a my lord, this invoice at page 16, annexure 2, my lord, that is BPN Motors Private Limited. Now, my lord, when I obtained the vehicle physical possession from this BPN, my lord,
No FIR has been,
no, my lord, no, my lord, no FIR has been lost. My lord, my learned friend can obtain an instruction, my lord,
Yes.
that whether
done an additional PP to obtain instructions as to whether any FIR has been lodged against the present petitioner. Again, none.
29/11/25.
Lord, police may not harass, my lord, this that observation may kindly.
When? 29.
29.
Lord, my lord, 29/11 Saturday.
01.
Lord, may I pray, my lord, that without any case I may not be harassed, my lord.
What kind of order is that?
My lord. Oblige, my lord.
Wait, please, your lordship. In this case, I am convicted under section 304 part 2, and I am sentenced to undergo imprisonment for a period of 7 years, your lordship. May please to issue notice at this stage and on May I pray that on the next date, your lordship, the suspension of sentence may be considered.
Third learned counsel for the petitioner decision application under case to the third case to
Notice to the respondent number 2, your lordship.
the
The
number
informant of the
kept
case.
by registered
be
post
withdrawn.
with AD within 3 days. This the matter again on.
TCR may also be called for, your lordship.
Also call for the TCR, scan copy of the TCR.
Deeply organized. 8-1.
May I please, your lordship, for time being, lordship, on late lordship for number 20.
May I know? It's instruction. Line of friend is taking instruction whether the matter has been investigated by the NI or not.
Yes.
Lordship, this matter is not investigated by NIA. I verified in the branch also and in the case, charge sheet has been filed by the state police.
All right.
Lordship, the FIR is page 9, Lordship.
So who has the CD?
Charge submitted to
Rashid submitted.
Records called for, Lordship, because 10 copy was. Yeah.
Not received. Received.
So for you. First list of.
Oh. Just give it to PP.
Hello?
Take up day after tomorrow. I don't think you'll be able to go through that in the course of the day,
Yes.
PP. Voluminous. Is submitted by learned counsel representing NIA that the case was not investigated by NIA and charge sheet has also been submitted by the state police. 10 copy of TCR has been received. And additional PP 6. Some time to go through the same. Hence, please the matter again on.
Right.
May I please, your lordship? Yes, and
23, 24, 25, 26, 30, and all are same, I think out of same apparatus.
Here, my lord, with all respect, my lord. Very unfortunate happening, my lord. Although case has been registered under section 103, my lord. But definitely it would be a case of, my lord, ultimately, my lord, 105, my lord. And the quantum of punishment provided, although life is there, my lord, it may come down to 5 years also, my lord. Fight between a group of students and another student, my lord. And unfortunately, my lord, the student from the other state, he expired. And this is not a, out of all, my lord, I represent 3. Regarding 3, my lord, I am stating only for 1 at the moment, my lord. Item number 23, my lord. He is an epilepsy patient, my lord. It is reflected from day 1, my lord, even in the order sheet of the learned magistrate, my lord. The background of the case is this, my lord. Nobody is named in the FIR, my lord. FIR is at page 13, my lord.
Sriyam Deka.
Yes,
Nobody is named, my lord.
but Lordship,
All are, my lord. It was, my lord, beating is there by all arrested persons and several others, and 2 are on pre-arrest bail. They are also possibly prime allegations, my lord. They are out, my lord. These are inside. Out of these 3, my lord, the lordship sought for the, my lord, that FSL report, my lord. Here, my lord, date is not in dispute, but anyway, it was sought for, my lord. While talking to, he said, my lord, he'll be seeking time because FSL is not there. So regarding the rest to my lord, my prayer for bail, my lord, if date is given, my lord, it can be postponed, my lord. But
25.
my lord,
Yes. Item
exactly.
numbers.
Honestly, my lord.
24,
24, 25,
30 years.
32 car.
24, 25, 26, 30.
No, no, 30. 30 I do. Oh, 30 is also ours, my lord. with all respect, my lord.
Student was brutally killed and by assaulting some lathis, bamboo stick and some pelting stones. Only because of
PM report is not available.
PM report is available, multiple injuries are there. FSL report is, opinion is still pending because of not received on the FSL.
That is not relevant, I think.
But exactly, my lord.
Eyewitness
Exactly, my lord.
implicated the prisoners and other witness, all are implicated by this.
Including the persons who were granted the privilege of pre-arrest bail, my lord. Because nobody was named in the affair, hence it was granted, my lord.
Only thing is that Lordship going through the case diary and the injuries sustained by the disease Lordship and granting them at this stage of investigation bail sent a wrong message to the society and the community of the students Lordship. I am setting a statement of the eyewitness Lordship. Going to read this. They started threatening us by using abusive language, and since we are in Assam, we are threatened to speak in Assamese language.
My lord. Page
Page?
36, my lord. The operative part, my lord, or lordship will find at page 38, my lord. Page 38, second paragraph, my lord. May I read, my lord?
Yes.
On the other hand, learned additional public prosecutor had produced the case diary of so-and-so and had submitted. Though there are incriminating material against the other accused person, it appears from the case diary that the present petitioner is the owner of the vehicle which was seized in connection with the case, and he allowed his brother, who is the main accused in the case, to use the vehicle, my lord. This is the content. This is the, my lord. This is the reason, my lord. Now they have filed the charge sheet, my lord. In the charge sheet, my lord, your lordship will see, my lord, at page 20. Page 29, my lord. One is Hanifur Rahman, number two is Dewan Samsuddin, three is Saidul Islam. And my name, my lord, and Hibzur Rahman, son of so-and-so, district so-and-so, is sent up to face the trial in the honorable court, my lord.
You are Hifzur Rahman.
Hibzur Rahman, my lord. Admittedly, my lord, I am the owner of that vehicle, my lord, and the vehicle was seized, and I filed a Jimma petition, my lord, that was allowed. That was allowed. That was also allowed, my lord. Now your lordship will have a look in the charge sheet itself, my lord, page 25, my lord. It's a Hibzur Rahman, my lord. That photograph is also not mine, my lord. Someone's other photograph has been affixed there, my lord.
Yes, what is the material against him, PP?
My lord, may I kindly say, this is the application for quashing of the charge sheet, my lord. Now, before the trial court, my lord, charge is yet to frame, my lord. Now, I have, my lord, also perused the scan copy of the record, my lord. The direct implications are not there, my lord, admittedly, my lord. But whatever my learned friend is saying, my lord, he is the owner of the vehicle, my lord, and he has given the vehicle intentionally knowing that, my lord, they are committing some offense, my lord. So let them place, my lord, all the materials at the time of framing charge, my lord. Because, my lord, quashing at this stage, my lord, this is premature, my lord. So trial court may not frame charge also, my lord, by going through the, my lord, record, my lord.
If there is nothing in the case diary to implicate me, why should I go to the court, my lord?
The vehicle has been used and that vehicle has been given Jimma to me.
Now you know there is no material against you. There is every possibility charge will not be framed.
Definitely, but that
Will
was
not
what
come.
That's true, my lord. That's true, but I have filed this application, my lord, for question for. In the FIR also, my lord, my name doesn't appear.
Lordship perused the search sheet, my lord, two accused persons, my lord, who was, my lord, arrested, my lord, in the, or in the named in the FIR, my lord. They have been, my lord, not searched, my lord.
That is not
After
related
further
to
investigation.
investigation.
But these accused
Those
persons-
were shown arrest, my lord. Those were shown arrested.
The question is, why was he charge sheeted?
But now, my lord, lordship may see, my lord, the section which are against me, my lord, 307. How 307 comes, my lord? 420.
Is there any material indicating that he knowingly gave his vehicle to the main accused?
Yes, my vehicle was used, my lord, that I am
No, it was
admitting. my
used
lord.
knowingly.
That is
I can
that
take
is
your
the-
vehicle and
that is the,
commit
my
some
lord,
offense. It's a different matter.
It is the, my lord, materials perhaps, my lord, in the search, my lord, that he knows, my lord.
What is perhaps? We'd like to know.
307 will attract, will come, my lord.
307 has been, my lord, may not come against him because, my lord, while they were asked, my lord, the vehicle was intercepted. He was not in the vehicle, my lord. While the vehicle was intercepted, my lord, they did not stop the vehicle, my lord. And by, my lord, breaking the barricade, my lord, they went off, my lord. Straight away, my lord. Then, my lord, police says them, my lord. And, my lord, the accident occurred, my lord, in both the police vehicle and their vehicle, my lord.
But at that time, the present petitioner was not there.
Not there, not there.
I have no way linked, my lord. Only my vehicle was used, my lord. And in fact, my lord, the public prosecutor, my lord, in the bail application has fairly submitted, my lord. It appears from the case diary that present petitioner is the owner of the vehicle which was seized. Hello, B. Sharma. He fairly submitted, my lord. There were incriminating material against the other accused person. It appears from the case diary the present petitioner is the owner of the vehicle which was seized. Page 38, second paragraph. Further, my lord, page 38 also, my lord, the honorable court has also held, my lord, that appears from the record, there is no specific allegation of the present petitioner himself being involved in the alleged ATM fraud scam. However, it appears that a vehicle which was used, my lord, that much, my lord.
We'll see.
Fine.
Dispose.
Dispose of, my lord.
Yes.
I am obliged.
Also, we have received a case diary, but in the case diary, postmortem report not available. I have communicated the OC of the concerned police station, lordship. They have received the postmortem report, but visa is still pending, lordship. So
Item, this is 20.
27. So without the PM report, lordship, it's very difficult to assert in the case, lordship.
Neither PM nor FSL, nothing is available.
Nothing is available. So they have preliminary PM report is they have collected, lordship. After communication I have made with the OC concerned, lordship.
What is the allegation?
Allegation is that a person was murdered, your lordship, and the accused petitioners were before this court, your lordship. They are involved in the case. A conspiracy was committed. Your lordship may kindly peruse the forwarding report for a moment at page 15. May I read, your lordship?
Is other than that, other than the medical part,
Other,
CD is there.
it is here.
Is what is the material against the present petitioners?
Perusal of the forwarding report makes it clear that there are involvement, your lordship, of the accused petitioners. My only respectful submission, your lordship, they are behind the bars for the last 51 days. Considering their length of detention, if your lordship may kindly, on any stringent condition, your lordship.
Accused also admitted into their statement of confidential statement.
Fine.
This is premeditated murder, you know,
One of- yes.
51 days is nothing.
One of the statement of
Then
the.
may I pray, may your lordship may fix it after 20 days, your lordship. At least for that thing. If I may kindly pray, your lordship. Because evidently, your lordship, a crime has been committed, your lordship.
Confidential statement they have made before the confidential statement, lordship, it is.
After a period of 20 days, if I may kindly pray, your
And after a period of 20 days, you may not get it.
lordship, kindly. After some time.
Is on prayer of learned counsel for the petition is the matter on 20 days or piece of 30 days date.
I'm very grateful, your lordship. Very grateful.
Did be sent back and resubmitted?
We are reading of the FIR, which is a trap case, lordship, which says that they have called him for to kidnap him and some ransom were taken, lordship. As per the FIR. In the fact, lordship, what happened? The accused person, lordship, were supposed to get money from that person, lordship, and for the realization of that money, a civil suit has been filed and a complaint before the DSP. Complaint before the GCP was also filed against the complainant, lordship. On the other hand, the complainant is not so innocent, lordship. There is some several criminal case also pending against the complainant, lordship. And the kidnap person, lordship, that is a trap case, and at the place of occurrence, everyone was caught, lordship. He called the accused person to collect the money which were due to them, lordship. Page 11 is the FIR, lordship. It clearly says, lordship, that is that did not took place, lordship. Page 22.
Yes, PP, what is there in the CD?
Lordship, sufficient materials are there, Lordship, against all of the petition. And 183 statement of victim is there who implicated the name, Lordship. And one IO notice there, Lordship, where it is stated that the victim informed that he had received multiple calls from random phone numbers wherein he and his family member were threatened to withdraw the complaint. This is create a situation of fear and panic within his family, Lordship, and statement of all the accused, Lordship, how they have committed this, Lordship. I have flagged my, Lordship, kindly vote.
Lordship, prior
Against there the habitual involvement, Lordship, habitual offender, Lordship, against them, Lordship, cases were also, Lordship, registered earlier, Lordship. Kindly pay this.
prior going to the case diary, lordship, will kindly see page 40, lordship. This is the reason for calling him, lordship, for the money, page 40 of my petition, lordship. Sorry, lord. Civil suit is pending, lordship, for the realization of 1 crore 52 lakhs, lordship, 75,000. Page 40 is still pending, lordship. And page 33, lordship, is a complaint before the DCP, lordship.
even that informant is threatening us, Lordship. Page 30.
For Lordship, realization of this money, this Riaz Ahmed, Lordship,
And
they have, Lordship, this group, Lordship, the B. Lachi Sena, they went there for realization of money, and if they realize the money, then they will give 10,000, 10 lakh to them as percentage, Lordship.
Riaz's name in the FIR, Lordship. Lordship will kindly see the Riaz. Then I came to know about 2% namely Riaz Azhar and Chinmay Datta. He is named in the FIR, Lordship, the paid person, Lordship, who have filed this, instituted this civil suit, Lordship, for realization of 1 crore 52 lakhs, Lordship. And thereafter a complaint before the DCP has been filed, Lordship, by the Riaz Ahmed itself, Lordship. Page 33. The trap case, Lordship, we have planned it, Lordship, with the police. As soon as they came, he have called the police, Lordship. The trap case fully long. And in the case diary, nothing has been mentioned regarding that, Lordship, realization of the money, that civil suit has been filed. A DCP complaint has been filed in the same police station, Lordship, where DCP sits, Lordship, in the dispute. Whether
Lordship,
that has been
one
clear.
IO notice there, where it has all clearly mentioned everything, Lordship, an IO notice there.
Regarding that, Lordship, if someone gets, Lordship, 1 crore 52 lakhs, Lordship, then definitely he will give call, Lordship. I'm not denying to that fact, Lordship. He informant himself saying, Lordship, that I'll pay the amount, you withdraw the civil suit. That was the talk between the informant and the Riaz, Lordship. And on that particular day, he asked us, Lordship, to come and meet to take delivery of half portion of that amount. And the secondly, Lordship, the second petition, the Biras Ballabh Kolita, Lordship, he was not present in the place of occurrence, Lordship. He was in Naharlagun on that Shergaon, Lordship. And when they were arrested, he came to police station to meet them, Lordship. And that point of time, this person, Lordship, of the next case, he was arrested. He was shown arrested in this case, Lordship. That Biras, that I have annexed all the inner line permits and all everything, Lordship. Then a date and all is there, Lordship. Annexer 5. Annexer 5, page 27, Lordship, will kindly see. And the page 28, 29 are the photographs of date and time is there, Lordship, on the on which date he was there, Lordship. As soon as he came to know about the arrest, he rushed to police station. From there, and police booked him under in this case, Lordship. And together, Lordship, 31 days, Lordship. And wherever as per the allegation,
This person is also implicated.
Lordship. All the petitioners, Lordship.
Date of incident is 25/10.
No, Lord.
Huh?
24. 26.
26.
Oh.
So this is dated 25.
No, that day,
We'll get it
Lordship.
back.
Inner line permission good बोलता है next session है यहाँ पर lose हो
Page 27 top. Date is 25/10.
No, 25 were there, Lordship. It was valid up to 5/11. Valid up to 5/11, Lordship. Lordship will see down below, valid up to 5/11, Lordship. Twenty-six is the date of occurrence. Early morning. Place of early morning, Lord. And distance also, Lordship, that 300, more than 300 kilometers. And as per the allegation of the FIR, kidnap, Lordship, attempt, Lordship, as per the allegation we see, Lordship, that at the place of occurrence, police immediately came and rescue all of them as per the version of the FIR, Lordship. Whereas the original fact is something different, Lordship. That I have already annexed in the petition regarding that realization of that money, Lordship, 1 crore 52, and a complaint before the DCP also, Lordship, the same police station, Lordship. Before the occurrence, Lordship, we have placed that complaint before the DCP, Lordship. On 24th, we have lodged the complaint that I have annexed on page 33, Lordship, in the first petition, Lordship. Item number 28, Lordship. Right. Page 33, Lordship, will see the date, Lordship.
These are other
It's on
photographs,
24th
annexure
10,
6.
Lordship.
Annexure 6 is 28. That is Sunday, 26th.
কোনখানে রয়েছে?
Date of occurrence. They are supposed to be in West coming.
Lordship, on that date, Lord.
How many days? No?
31 days, that's all. Considering Lordship, any stringent condition, Lordship, local person, Lordship, the offense is not committed, Lordship, that is an attempt, Lordship, as per the allegation of the FI, Lordship.
What is the other one? Last one?
May I please, your Lordship? Lordship, already learned senior council has already learned senior council has gone through has got the facts of the FIR, Lordship. Now, Lordship, the actual fact why the present petitioner has been arrested is that when the incident took place, he was there. I'm not denying. I was there at the place of occurrence, but it is a usual tendency of every person whenever such chaotic situation arises, they go to the place of occurrence, and when he was present there, he was arrested, Lordship. And Lordship, the two sections of law, one is 140, another one is 308, Lordship. 140 is no way implicable in any of the case, Lordship. If I come to 140, may I read the 140, Lordship? The section 140, Lordship. Lordship, section 140 says that whoever kidnaps or abducts any person or keeps a person in detention after such kidnapping or abduction and threatens to cause death or hurt to such person, or by his conduct give rise to a reasonable apprehension that such person may be put to death or hurt or cause hurt or death to such person in order to compel the government or any foreign state or international intergovernmental organization. Lordship, this is what 140 subsection 2 says. Lordship, now if 308 subsection 2, whether there is any statement, whether there is anything against present petitioner that I was there in the vehicle, that I have committed such extortion, because 308 says about whoever commits
He is not
extortion.
FIR named accused, otherwise what is the material against him?
Lordship, statement of there, Lordship, I have to, 183 statement.
Has named him.
Some accused the petitioner, Lordship.
Master.
Rohan Ali.
On IO notice, their Lordship, said that on 26/10/25, the said group of individual Lordship, including Bishwajit Dole, this Rohan Ali, Chinmoy Dev, Mohan Bora, Injamul Haq, Neetu Ahmed, Riaz Ahmed, and Biraj Vallabh, Lordship, Biraj Vallabh Kolita. Said group of individual abducted the victim and demanded ransom from his family member for his release. During the period of abduction, the victim was physically assaulted and tortured by the abductors. When the victim's family expressed their inability to arrange the demand amount, the accused person asked his family member to hand it over all the valuable jewelry which were they have subsequently won. Upon receiving information regarding the abduction, police conducted an immediate operation and successfully rescued the victim and apprehended 6 individuals on the spot. They are named accordingly Bishwajit Dole, Neetu Ahmed, Injamul Haq, Mohan Bora, Chinmoy Bora, Rohan Ali.
This is the case, Lordship, but there is nothing.
And during interrogation, all the apprehended person discloses the name.
The abduction was supposed to have taken place in a vehicle, isn't it? So how many persons in that vehicle? Total,
8, Lordship.
8 people.
8.
What was the vehicle?
I think it was Scorpio, Lordship.
Scorpio.
After that, it came to a halt at one point, and then police also came. At that particular point, the chaotic situation arose, and then I was there at the place of occurrence when these 2 vehicles came to halt. But otherwise, I'm not involved in the extortion, Lordship, as per the allegation in this FIR.
Okay, you send a CD.
Lordship has heard yesterday, my lord, and Lordship has, my lord, asked, directed me to, my lord, go to the 47, 48 notice, my lord. My lord, I
Regarding?
have 47 and 48 notice, my lord, whether it is complied with or not, my lord. But by humble submission, my lord, that has been complied with, because, my lord, he has been caught red-handed, my lord. Now, my lord, Lordship may kindly peruse this scan copy, my lord. I have, it scan copy to the office. The orange color flag mark, order dated 23/5, maybe, I may be wrong, my lord. Color flag. May kindly peruse this order, my lord.
Yes.
Now, my lord, by humble submission, my lord, when a person is arrested, my lord, times of my lord 47, 48 notices, that is mandatory, my lord. Now, my lord, Ihan Kumar, then Provin Purkayastha, so then my lord, Pankaj Bansal, and my lord, now the Johnson case, my lord. Nowhere stated that, my lord, notice is not required to be served. Yes, notice is required to be served. But when a notice is not served, or the person says that I have not given the 47 and 47, 48 notice, my lord, then he has to show, my lord, that how he has prejudiced, my lord. In this case, my lord, he is, my lord, from this order itself, my lord. It is very much clear, my lord. He knows, my lord, why he has been arrested, my lord. Only, my lord, if, my lord, he could show that, my lord, prejudice has been caused to him due to non-service of this 47 and 48 notice, my lord. Then only, my lord, the violation of Article 21 will come, my lord. This is my humble submission, my lord. Down below, my lord, that is his, my lord, person has been recorded by the trial court, my lord, when he was produced immediately after arrest, my lord. The very same day, my lord.
Deputy LADC is present to represent the accused person.
Down below, my lord, 2-3 paragraphs.
Eh? Yes. Yes, it appears from this order that Deputy LADC was appointed and he was even also present on the day of production.
Yes. Regarding, my lord, ground of arrest, my lord, he has said, my lord, he is well aware about the, my lord, the reason of arrest and ground of arrest, my lord, why he has been arrested, my lord.
Has been said in the last case, Mihir. And
May I submit, Lordship?
just a moment.
Lordship, there is a total violation of the relation 47 and 48, Lordship. The notice given under section 47 and 48, Lordship, there is no grounds of errors. Even there is no facts of the case is contained in this the notice, then why the accused has been arrested? Simply the penal provision is mentioned, Lordship, and 48 also, Lordship, the same, Lordship. As per the observation of the Honorable Supreme Court in Bihan Kumar, Lordship, Pravir Purakasta, Lordship, the notice should be given to
So
the
that I have
accused
already submitted, my lord.
grounds of
Yes,
arrest
it is very much clear, my lord.
in
Ground
writing,
of arrest has to be submitted in writing. Even, my lord, statute has also said.
in writing, Lordship.
Ground of arrest has to be furnished. But,
In-
my lord, in those decisions, my lord, you will have to show, my lord, when you will, my lord, file a bail application, my lord. Alleging, my lord, violation of fundamental right, my lord.
Lordship,
Because he has not placed his application on merit, my lord. He said that his right has been violated because 47 and 48 on notice
in
has
various,
not been complied with, my lord. That means, my lord, he has no knowledge for what purpose he has been arrested, my lord.
in various bail application, Lordship, this court is allowed to go on the accused on this ground, Lordship. I'm relying on the Lordship on Ahmed Mansoor, Lordship, Ahmed Mansoor judgment, Lordship, where the grounds of arrest was, Lordship, explained by the court at the time of production, Lordship, and a copy of the same, Lordship, furnished to the counsel appearing for the accused, Lordship. Then also in this case, Lordship, the Honorable Supreme Court held that there is a violation of, Lordship, the fundamental rights, Lordship. 47, 48, there is a violation, Lordship. Ahmed Mansoor, Lordship.
This case is, my lord, under what section, my lord? That is we looked into, my lord. This is a case, my lord, of commercial quantity of contraband, my lord. And, my lord, this has been recovered from his conscious possession, my lord. It is not that somebody else has implicated him, my lord, and he has been arrested by police, my lord, and no ground of arrest has been furnished.
And Lordship, in regards to the Lordship prejudiced, Lordship, it was stated in Darshan case, Lordship. Lordship, our High Court is very much clear about that the earlier judgment should be followed, Lordship. In Lordship, the division bench, Lordship.
Yes, earlier judgment is to be followed when there is a conflict between
Yes.
the two.
Yes, Lordship. Bihan Kumar.
But it appears that Darshan has referred to Bihan Kumar and explained it.
Yes, Lordship.
Supreme Court itself has explained its own judgment.
Yes, Lordship.
So where is the conflict?
No, prejudiced, Lordship. In case of the prejudiced, Lordship, I have the coordinate bench bail application, Lordship, after upon discussing all these issues, Lordship. Well, where person is caught red-handed or, Lordship, his counsel, Lordship.
Which judgment? This Mansoor.
Lordship.
This judgment. I'm not asking about the DB judgment. I'm asking about.
Lordship, coordinate bench, Lordship. In a recent bail application, recent bail order.
You pass over the Supreme Court judgment. And anything else you want to?
Ahmed Mansoor, Lordship.
You have a copy?
Yes. Lordship, Pravir Purakasta, Lordship, it is very much clear, Lordship. The basic fact in with the investigation should be part as a grounds of arrest, Lordship.
Examine. CV.
They have obtained instruction, my lord. No case has been registered and pending, my lord, again. In my lord, Rongia PS case, my lord, Rongia police station.
I'm concerned about wrong way PS only.
I have filing on Rongia PS.
So no case against you. Learned additional PP, Mr. Rajay Borua submits on instructions received that no case has been registered against the present petitioner at Rangya PS RANGIA. Hence closed.
My lord, in this case, my lord, petitioner was in interim bite order dated 21/5/2025, my lord, after perusal of the CD, my lord. After perusal of the CD, my lord, this honorable court bite order dated 21/5/2025, my lord, allow the petitioner to go on interim bail, my lord.
Why interim after the
My
CD?
lord, at that time, the objection submitted by the learned people, my lord, was that up-to-date CD is required, my lord. That's why my up-to-date CD was called for, my lord. Lordship may peruse the para 7 of the said order, my lord, para 7 and para 8, my lord. Order dated 21/5/2025.
Now investigation has already been completed, my lord, and charge is submitted.
But then my lord, order dated my lord, absolute, my lord, interim prayer may absolute. Interim bail.
After becoming major CS again, hello.
Yes, my lord.
CD is not with you.
CD not received, my lord, because charge is submitted.
The statement of the victim itself is not available. It was not available earlier also.
My lord, that is my lord, as per my information, my lord, she never deposed before the magistrate, my lord. Magistrate no statement recorded under section 164, my lord. Though there is a section under section statement of victim under section 161.
All right, let's call for the TCR then.
Yes.
Learned additional PP submits that CS has been submitted by CS number.
CS number 57/2025, dated 30/10/2025.
Call for the scan copy of the TCR. List again on so and so interim order passed earlier to continue till the next date of listing.
Bless, my lord.
Well, in this matter, perhaps CD is not there. Petitioners are on interim.
Case that is not received, my lord.
Up to date CD not received. List again on. Interim order passed earlier to continue.
18/12.
Highly obliged.
Particularly, my lord, case that is not received, my lord.
Lordship, it is on Jalukbari PS since last 2-3
Updated
occasions.
CD not received. List again on.
8/12.
Interim
Lordship,
order
there is
passed
interim order in this.
continue till the next date of
Alright.
listing.
12.
Item 34.
34 also, my lord. Case that is not received, my lord.
Same order. Interim to continue.
1812.
Maybe the lordship. Lordship, FIR is a page, test look page 10 lordship. Here the allegations is like informant's daughter lordship, he is speaking a disabled lordship. And they came to know that now she is a pregnant lordship. So lordship, they doubted me lordship. This is the allegation lordship. My lordship, statement lordship, my plea lordship, I have stated in paragraph 4. Clearly I have stated the details lordship, what has happened with me lordship. What has happened with me lordship, I have stated here clearly lordship, paragraph 4 lordship in my petition. I don't know lordship what the CD says lordship. Actually the matter is that lordship, somebody might have lordship done this illegal act lordship, but my confident lordship, I have not done this lordship. Some villager lordship, 2% lordship, that leaders lordship, village leader lordship, they lordship several times they claim some money from me lordship, but I denied lordship because I have the confidence I have never done this lordship. That's why I have denied lordship. And later I came to lordship that they said 2% lordship, they also claim money from other boy lordship and they also taken money lordship from him lordship. But he's not in the FIR lordship. Now lordship, as I denied to pay the money lordship, they have taught the girl lordship. Lordship, and accordingly lordship, they have included in the FIR lordship. Others lordship, I have no any such act lordship, I have not their lordship. And in fact, lordship, the period lordship in which they indicating lordship, at that period lordship, I was in the Guwahati lordship, and I am doing as a mason lordship. I am a so lordship, I was in the Guwahati lordship. So for the FIR said lordship that prior to she's 5 months pregnant lordship, at that time lordship, I was in Guwahati lordship. So lordship, I full confident lordship that I have never done this lordship with that girl lordship. And that only the said 2% lordship, they might have taught her lordship and accordingly they lordship, she may indicate me lordship. Otherwise, I know that lordship, I have never done this lordship. The case that a physically disabled girl forcefully raped by the petitioner lordship and a 183 statement recorded, she has fully implicated the petitioner and she is now 5 months pregnant. So going to witnesses.
Where from are you saying that CD is not here?
No, we have not received a case.
We are an interim matter.
Interim person.
Did not
We
receive.
made a prayer for another district.
He did not receive list again on so and so interim order passed earlier to continue.
1812.
Oh, bless.
Okay, they not received.
Same order. No interim.
I'm not interim. Not interim.
No interim is there.
So 812.
Please, your lordships. In this case, I am on interim lordship and I have already appeared on 13 and thereafter on 3-4 occasions. Till yesterday, I have appeared before the IO lordship. And the FIR is at page 23 lordship.
So this is the case there.
Statement is there.
Statement is only 180 statement is here, but 180 statement is not here.
I have appeared already lordship.
His statement is here. It is not
Yeah.
statement is here. He has appeared and
Till that I am appearing. Yesterday also I appeared before the IO on call lordship. And I have been,
he has appeared and statement recorded.
Her statement will be same as FIR.
Yes, they were following law relationships and marriage was yet to be solemnized and applied for us court marriage also. But later on, he has refused to marry.
In the
Later on, refused to marry lordship. That's why that and made physical relationship promised to marry. That is the ground rules. He has appeared and appeared.
dated 10/11/25. Para 1, 2.
He's from the informant side.
I am for the informant, madam.
He also at Para 1 you had also heard Mr. So and so learn. For any submission?
In relationship, my lord, they will apply for the
Areas called for has been. Appears that pursuant to interim protection granted. The petitioner has appeared before the IO and his statement. Regard to the nature of the patients, interrogation petitioner not be necessary. Accordingly, the PRS bail is allowed. Interim PRS bail dated 10/11/25 is hereby made absolute upon the same conditions.
Duly applied, Lord.
May I please, your lordship?
It is.
My lord, page 8 is the FIR, my lord. Short FIR I want to read out, my lord. Page 8. With due respect, I humbly beg to state that about 1 year ago, I have known to above mentioned accused person and developed love affairs. After development of the love relation, the accused person promised to marry me, and in this regard, about 5 months ago, he used to take me to different places to travel and often had physical relations.
Charge sheet has been submitted. What do you want? You will appear there or there is no interim measure?
It's not there, Lordship.
Hmm?
Interim is not there.
Okay, call for the scan copy of the TCR. Submitted, that charge sheet has already been submitted by CS number.
CS number 66/25 dated 09/10/25.
Call for the scan copy here along with CD.
Yes, Lordship.
Please done. Give it there. No, interim 2 weeks of did.
Lordship,
The petitioner of the family members of the main accused, my lord. The main accused has already been arrested and he is in custody, my lord. Only allegation against the
It is here.
petitioners is that, my lord.
up to date, CD needs to be sent back, Lordship. Statements are not available here in the.
No, there is no interim order, my lord.
Here it is written on 13/11/25 interim.
No, not interim.
Lordship, I have to go through the case.
They are the family members, my lord, who are residing separately in separate district, my lord. And the only allegation against them, my lord, conspiracy, my lord. And the main accused is arrested and he is still in jail, my lord. Kindly see the FIR, my lord. Only conspiracy, my lord.
ইয়াত তদন্তকালত সাক্ষীবাদী সোধপোছ কৰি তেওঁৰ জবানবন্দীত মাইকে নিজৰ শৰীৰত জুই লগাই দিয়া বুলি জানিব পৰা যায়। সেই সময়ত ঘৰটোত আৰু তাইৰ স্বামী নদীৰ সিপাৰত খেতি কাম কৰি আছিল বুলি সাক্ষী statement of witnesses আগতে কোনোদিনা মনোহৰৰ ঘৰত কাজিয়া পেচাল হোৱা শুনা নাই।
Who are they, the present petitioners?
Petitioner number 1, my lord, he is the elder brother of the husband of the victim lady, my lord. And the petitioner number 2, my lord, he is the cousin brother of the accused number 1, who is residing near the house of the informant, my lord. And the petition number 3, my lord, happens to be the paternal uncle of the main accused, my lord. He is also living separately, my lord.
PCI received.
PCI received.
None appears list again on next week.
May I please, your lordship?
Hmm.
My lordship, due to an inadvertent mistake on our part, the amended cost title could not be filed, so we seek some time to file the amended cost title page.
Counsel for the petitioner prays for further time to submit. Amendment for
Amended cost title page.
amendment of cost title. Prayer is allowed list again. No?
16th. Oblige, my lord.
May I please, Lord? The connected appeal has already been admitted, my lord. And record was called for consideration of the bail, my lord.
Hmm?
The record was called for, my lord, for suspension of sentence, my lord. Normally, the conviction has been, my lord, awarded, my lord, under section 304, part 1.
7 years.
And 7 years, my lord. And incident took place, my lord, out of heat of moment, my lord. The petitioners and deceased, my lord, their friends, they were, my lord, consuming alcohol, my lord. And when there was shortage of alcohol, my lord, he said.
So this is for fixed period, 7 years.
Lost.
No separate IA.
We have filed IA. IA has come to develop for consideration.
IA. Asen. Big deliver. Similar order type. 4 years.
I have disposed of.
Yes, I is disposed of.
Oblige.
I had to dispose of ensemble of the dealing. Mashvik dealing.
May please, your lordship. In this case, we have taken step. The office note says that no service report is in respect of service dated 27/8/25. The respondent number 2 has yet been received back upon from usual notice. So, my lord, service report so far our instruction, notice has been served upon the parties. The petitioner was also available in the police station, and the notice was served through the district magistrate Kamrup. So the report from service report may be waited for some more time.
It appears from the office note that service is not yet complete, hence await service. List again on after 4 weeks.
4 weeks to be late. 4 weeks will be too long, my lord, sir. They are only to verify.
2 weeks.
2 weeks, my lord.
Hearing order passed, I'll let you continue.
Please, Your Worship. Notice service has been completed and respondent number 2 has filed their vakalatnama also. Their name is showing the post list also. Let the matter fixed by admission here. Let the matter fixed by admission here.
You are appearing.
I'm respond to the matter is very short, my lord, and say regarding check. So it may come on Friday or Monday, my lord, so that.
Learned counsel has entered appearance on behalf of respondent number. Hence list the matter for admission on.
28, 9, it may be 8, my lord. 9 I have some other problem. 8.
Please allow. The private report is 17.
Also TCI
It is not completed.
TCR not received, service also not on respondent number 2 also not complete.
Interim protection is there.
List again on so and so interim
right?
order. Past earlier shall continue till then.
Interim is there, Lordship.
Yes.
Okay.
In this case, my lord, service report is awaited as per the office note, my lord, that I am told my file.
Service on respondent number 2 is not yet complete. Await service list. Again on.
Respondent number 2, my lord, yes.
List again on.
My lord, in the month of January, it's not possible in the December, my lord.
Okay, given December.
My lord, deeply obliged.
Please, Your Lordship. The IA before Your Lordship is petition for condonation of delay in preparing the appeal, Lordship. The legal aid matters, Lordship. There is a delay of as Lordship 594 days, Lordship.
There is private respondent also.
Yes, Lordship, there is a informant, Lordship. POXO 6 is there.
So he has appeared.
No, Lordship, today is the first day, Lordship.
Then
Because of some official communication from District Legal Service Authority to this committee, Guwahati High Court Legal Service Committee. Bill from jail.
this is an application under section 5 of the Limitation Act. Condonation of delay of 594 days in preferring the appeal. So notice to the respondent number 2. To take steps. Registered post.
Please go through the office of the public prosecutor, Lordship.
Or concerned police station.
Consult police station.
Office of the petitioner to take steps to the office of the public prosecutor. Is the matter again on the date.
Please, Lordship. Lordship, here we have challenged the proceedings. But service, my friend has filed today vakalatnama matter for respondent number 2. So now matter may be listed for admission.
Mr. So-and-so learned counsel has entered appearance for respondent number 2. Hence, please the matter for admission on the date.
9th. No, 9th of December there. There is no stay matter, so Sarah, I'm deeply.